Now you are listening juristic laws. Although juristic laws cannot be treated as an independent source of international law, yet the view of the jurist may help in the development of law. Although juristic laws cannot be treated as an independent source of international law, yet the view of the jurist may help in the development of law. The views of the jurist are not direct source of international law, but they sometimes become instrumental in the development of international customs. According to Article 38 of the International Court of Justice, the works of highly qualified jurists are subsidiary means for the determination of the rules of international law. The importance of the works of jurists has been stressed by Justice Gray in Acute Havana. In the words of Justice Gray, where there is no treaty and no controlling executive of legislative act of judicial decision, resort must be held to the customs and usages of civilized nation, and as evidence of these, to the works of jurists and commentators who by years of labor, research and experience have made themselves peculiarly well acquainted with the subjects which they treat. Such works are resorted by judicial tribunals not for the speculation of their authors concerning what the law ought to be, but for trustworthy evidence of what the law really is. The case deals with seizure of finishing vessels, its cargoes and capture of sailors during the state of blockade. The Paquete Havana Act and the Lola 102 fishing vessels with Spanish flags on them in 1898 during the war between America and Spain. The warships of America blockaded the northern coast of Cuba, which was then a colony of Spain. The American warships seized these fishing vessels and, in order to punish them, started proceedings against them in the District Court of America. The District Court declared the fishing vessel and its cargoes at price. The owners of the ship preferred an appeal in the Supreme Court of America against the said order. The Supreme Court of America reversed the decision of the lower court and ruled that the claimants be given the money derived from the sale of vessel, cost of the case and compensation on the basis of the precedents and the established rules of international law. The court concluded that the fishing vessels and unarmed sailors who pursued their work honestly and peacefully could not be seized or apprehended during the state of blockade. International law exempts such fishing vessels and their sailors from seizure during the state of blockade. The seasons or determination of the organs of international institutions before the establishment of League of Nations, international customs and international conventions were recognized as the main source of international law. In addition to these main sources, juristic laws and decisions of judicial and arbitral tribunals were regarded as subsidiary means for the determination of rules of law. The Statute of PCIJ under Article 38 incorporated these sources and also introduced one new source, namely general principles of law, recognized by civilized nations. Article 38, however, did not at all mention decisions or determinations of organs of international institutions as source of law. The reason for this was quite obvious that by this time international organizations had not assumed such an important role as they have done now. The evolution of international organization represents a significant stage in the history and development of international law. International organization in its wider sense is the process of organizing complexity of international relations in a narrow sense. It is an international institution based on multilateral international agreement entered into by sovereign states. Its organs having autonomy of will, having permanent organs, and having distinct entity or personality separate from its total of its membership. Even before the establishment of the League of Nations, some experiments were made for development of international organizations. They can be classified into three stages. The Concert of Europe, a loose association of great powers of Europe, represents the first stage and is said to contain seats of present Security Council. The second stage is represented by two Hague conferences called Hague System, which contains the seats of present General Assembly of United Nations. Third stage is represented by the establishment of public international unions such as Universal Postal Union and International Telegraph Union. Both of these are now specialized agencies of UN, which contains the seats of present International Secretariat and Specialized Agency. The League of Nations may be described as the first comprehensive experiment in the development of international organization, which sought to combine all the above-mentioned three different aspects of international organization. It has been rightly remarked that the League of Nations pioneered all aspects of international organization. The UN had simply further developed, elaborated, and perfected this system. After the establishment of UN and of course the establishment of dozens of intergovernmental organizations which were brought into relationship with the UN and called specialized agencies of UN, international organizations have become a part and parcel not only of international life but also of national life. Their impact is clearly evident on every aspect of our life. For example, if there is a scarcity of food grains, FAO comes to the rescue of nations and their people. If there is a health problem, for example, spread of disease like WHO comes to our rescue. In respect of problems of workers and laborers, there is a yellow which has assumed such a significant role in this field that its conventions taken as a whole are called International Labour Court. It is said to be generally binding on all states. There is ICAO, which regulates relations of states in respect of international civil aviation, and the Council of ICAO is competent to decide any dispute relating to obstruction to international civil aviation. ICAO jurisdiction case India versus Pakistan 1972 is a glaring example of this. In fact, after the establishment of UN, most of the development of international law and its codification has been taken place to the instrumentality of international organizations. General Assembly, one of the principal organs of UN, has established International Law Commission, which not only surveys the whole field of international law but also prepares drafts and make recommendations to these aspects to General Assembly. The General Assembly, in its turn, adopts its recommendations and recommends the holding of international conferences for adopting international conventions on different topics. A large number of international conventions have been adopted in this way during last 3 decades. The ICJ, which has rendered signal service for development of international law, is in fact a judicial organ of UN Art 92 of the Charter says the ICJ shall be the principal judicial organ of the UN. It shall function in accordance with the annexed statute, which is based upon the statute of PCIJ and forms an integral part of the present charter. In view of these strong reasons, the decisions and determination of ordinance are now recognized as an important source of international law, although they do not find mention in Article 38 of Statute of ICJ, but ICJ itself has recognized it in number of cases. For example, in certain expenses of UN and ICJ held that the expenses incurred by UN in Suez and Congo crisis could be apportioned among the member states of UN by General Assembly. It may be noted here that in both these crises, UN armed forces were sent under Uniting for Peace Resolution 1950. The ICJ thus though indirectly upheld the validity for Uniting for Peace Resolution. Similarly, in Southwest Africa cases 1966, Judge Jessup of ICJ remarked that numerous resolutions of General Assembly condemning apartheid was declared an international crime by International Convention on the Suppression and Punishment of Apartheid adopted in 1973, which came into force in 1976. The World Court had declared it as violative of international law, and obviously this decision was based on resolutions of General Assembly as pointed out in the ninth edition of Open Aim International Law. The fact that the International Court of Justice, in its numerous judgments and opinions relating to international organizations, has always been able, without remarking upon the incompetence of Article 38, to dispose of the questions arising for decision, is a strong argument for suggesting that their activities are for the moment at least still properly regarded as coming within the scope of traditional sources of international law. While at present this can be regarded as merely providing a different form for giving rise to rules whose legal force derives from traditional sources of international law, there may come a time when the collective actions of the international community within the framework provided by international nations will acquire the character of a separate source of law. In the view of Scott, origins of international institutions may lead to the development of international law in the following ways. One is in international matter, their decisions are the intermediate or final steps in the development of customary rules. For example, it was ruled by Security Council of the United Nations that if any member absent from the Security Council meeting, then it will not be deemed to be a veto. This decision has helped in the development of the international custom on this point. Similarly, the Security Council can decide whether matter is procedural or important. Such decisions may help in the development of an international custom on the point. Two is the resolutions of governance of the international institutions may be binding on the members in regard to the internal matters of the institution. Three is organs of international institution can decide the limits of their competence. Or is sometimes the organs of international institution may make interpretation of the different provisions of their constitutional instrument. The decisions become a part of the law of international institution, which in its turn becomes a part of the international law. Some organs of international institutions are empowered to give quasi-judicial decisions. European Economic Community deserves a special mention. In this connection, organs of international institutions submit some matters to the Committee of Jurists for their opinion. The opinion of the Committee of Jurists is of great significance and may help in the development of customary rule of international law. An organ of international institution may refer a matter to the international committees of jurists for its opinion or for investigation of a legal problem. The opinion of such committees bears some weight and authority. In case concerning military and paramilitary activities, in and against Nicaragua, the International Court of Justice relied on resolutions passed by international organizations inter alia and cited them as evidence of the existence of customary rules. Thus, as evidence of customary rule prohibiting the use of threat of force in international relations, the court cited the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the UN as evidence of customary rule of non-intervention. The court cited the said Friendly Relations Declaration, the Declaration on the inadmissibility of intervention as evidence of a customary right of self-defense. The court cited the Friendly Relations Declaration and the General Assembly's definition of aggression 1974. Reference may also be made. Reference may also be made here to the decisions of the UN Administrative Tribunal. In the case of effect of awards of compensation made by the United Nations Administrative Tribunal, the International Court of Justice held that the tribunal was independent and truly judicial body, pronouncing final judgments without appeal within the limited field of its functions and not merely an advisory or subordinate organ. Its judgments were therefore binding on the UN organization and also upon the General Assembly which established the tribunal. In other subsequent two cases, namely application for review of judgment number 158 of the United Nations Administrative Tribunal and application for review of judgment number 273 of the United Nations Administrative Tribunal. Also, the International Court of Justice upheld the decisions of the tribunal. Ex equo et bono. After enumerating the sources of international law in Article 38.1, Article 38.2 of the World Statute qualify Article 38.1 of by providing this decision shall not prejudice the powers of the court to decide a case ex equo et bono it party if parties are agreed thereto. Thus, as pointed out by Mende O. Hudson, in a case where the parties are agreed that it may decide ex equo et bono, the provision in the statute would seem to enable the courts to go outside the realm of law for reaching its decision. It relies It relieves the courts from the necessity of deciding according to law. It makes possible a decision based upon consideration of fair dealing and good faith, which may be independent of or even contrary to the law. An international tribunal can decide a dispute, act echo et bono, and go outside the realm of law only if such power has been conferred on it may and had been conferred on it by mutual agreement between the parties. Some other sources of international law besides the above sources of international law following are some of the other substitute sources of international law. One is international committee. International committee. The mutual relations of nations are based on the principle of committee. In other words, when a state behaves in a particular way with other states, the latter have also to behave in the same way. According to Professor Oppenheim, International Committee has helped in the development of international law. To each state papers in the modern period, almost all the civilized states have diplomatic relations with each other. They send letters to each other for mutual interest. These letters are sometimes published. A study of these letters sometimes reveals that certain principles are repeatedly followed by states in their mutual intercourse. Sometimes these state papers help in the solution of a conflict or controversy. In the famous case of the Caroline 1841, the note of Mr. Webster, Secretary of State of the U.S., deserves a special mention here. In his note, Mr. Webster said that for intervention on the ground of self-defense, the necessity must be instant, overwhelming, leaving no choice of means and no moment for deliberation. Since then, it has been recognized as a rule of international law. Occasionally, an international controversy clears up a disputed legal point or advances the application of principles that have before received little more than an Ortios assent state guidance from their officer. It is mostly seen that a number of matters of the government of respective states are resolved on the advice of their legal advisors. These advices are also therefore sometimes treated as source of international law. Reason, reason has occupied a special position in all the ages. In modern period also it occupies an important place. It has performed a special role in the development of international law. Whenever there is no rule of international law to guide the court, the matter is resolved on the basis of reason. By reason, we mean the judicial reason through which principles are discovered to face the new situation which are considered valid by the jurist when there is no treaty or particular rule of international law to resolve any question. The court applies judicial reason. As pointed out by Pollack, the law of nations is founded on justice, equity, convenience, and the reason of the thing, and confirmed by long usage. The view of Pollack seemed to be correct in view of the conditions prevalent before the Second World War, because then most of the rules of international law were in the form of custom, and hence the court would take the help of justice, equity, convenience, and the reason of the thing to decide a dispute. The position has, however, changed after the Second World War when states entered into a large number of treaties to regulate their relations in different fields, where clear provisions of law are incorporated in treaty. The scope of applying the principles of equity, justice, convenience, and the reason of the thing diminishes. The importance of these principles, however, does not completely end because whenever the question of interpretation of any provision of a treaty arises or where there is some ambiguity, the court interprets it on the basis of the principles of equity, justice, convenience, and the reason of the thing. The court gets an opportunity of applying these principles, particularly when there is some ambiguity about the meaning of any provision. Equity and justice in the Barcelona traction case, Sir Gerald Fitzgerald emphasized the need to have a body of rules and principles of equity in the field of international law. Equity is used here in the sense of consideration of fairness, reasonableness, and policy often necessary for the sensible application of the more settled rules of law. Strictly, it can be a source of law and yet it may be an important factor in the process of decision. Equity may play a dramatic role in supplementing the law or appear unobtrusively as a part of judicial reason. The principles of the exception whereby existing rules are qualified to meet special cases is a form of equity which takes on the form of judicial legislation. Further, equity in the present context is encompassed by Article 38 1C of the statute and not by Article 38 2, which provides this provision shall not prejudice the power of the court to decide a case ex equo at bono if the parties agree thereto. This power of decision ex equo at bono involves compromise, conciliation, and legislation in a friendly settlement, whereas equity in English sense is applied as a part of the normal judicial function to not seek continental self-efficacy. The International Court also observed when whatever the legal reasoning of a court of justice, its decisions must definitely be just and therefore in that sense equitable. Nevertheless, when mention is made of a court dispensing justice of declaring the law, what is meant is that the decision finds its objective justification in the Constitution, lying not outside but within the rules, and in this field it is precisely a rule of law that calls for the application of equitable principle. There is subsequently no question in this case of any decision ex equo at bono such as would only be possible under the conditions specified by Article 38, paragraph 2 of the Court's statute. In the modern times, more attention is being given to the principles of equity and justice. It has been pointed out that there is some evidence of the application of the principles of equity and justice in such areas were demonstrated in the North Sea continental shelf case. One is the practice of states in their international relations, two is international customary law, and three is the administration of justice. The principles of equity and justice make their contribution in the international lawmaking and in the codification and development of international law. The principles of equity and justice have been referred again and again in the context of new international economic order and new law of the sea. Following suggestions and conclusions given in the article deserve mention here. One, the role of equity in international law is a pervasive one. Specific areas of application includes international customary law, the administration of justice, the settlement of disputes, judicial and non-judicial, the practice of states, international diplomacy, the structure and functioning of international institutions, and international lawmaking. There does not exist any universal or widespread agreement regarding the precise meaning of equity. Trees in the international system, equity as applied to a particular case, situation, or circumstance would usually turn out to be, in effect, the view of a decision maker or a consensus of decision makers as to what is reasonable and just in the particular case, situation, or circumstances. For is a principal objective of international society is to build a more equitable and just society. Lawmaking should reflect this principal objective of international society and should therefore be guided by the principle of equity and justice. Governments refer to equity as a flexible general standard. Its invocation is often in general terms and the consequences of its application are not set out in detailed form. The International Law Commission and the Sixth Committee are also guided spirit, by this spirit in their codification and development of international law. However, the International Law Commission, with the support of the Sixth Committee, attempts to go one stage further and to translate this spirit into actual rules. In some instances, equity is distorted to where it has proved difficult to agree on a more specific or precise formulation. Recourse to formulations causes in the language of equity can help to produce arguments, and in this sense equity is an important tool of international legislation. Indeed, equity as a legal concept is a direct emanation. Equity as a legal concept is a direct emanation of the idea of justice. This was observed by the International Court of Justice in Continental Shelf case and was affirmed in Frontier Dispute case. Thus, although equity and justice have not been enumerated as sources of international law in Article 38, one of the Statute of the International Court of Justice, they play an important role in the international lawmaking and in the codification and progressive development of international law. Resolution and declarations of General Assembly of UN as the source of universal international law. There is a great controversy in regard to the legal significance of the resolutions and declarations of the General Assembly of the United Nations. Some jurists are of the view that they are only of political significance and have no legal importance. On the other hand, some jurists hold the view that under certain special circumstances they may have legal implications and some of them may even have binding effect. Ordinarily, it may be said, as Judge Jessup pointed out, that the resolutions of the General Assembly are not of true legislative character. Judge Jessup has, however, pointed out that if on a particular subject many similar resolutions are passed as an apartheid, then they indicate the contemporary international standard, and the court is bound to take them into consideration while giving its decision. Besides this, those resolutions which are of law-making character serve as an important link in the development of new principles of international law. Lamb Brownlee has also written that the resolutions of the General Assembly are not binding upon the members, but when they are related to the general rules of international law and are passed by the majority of states, they become the evidence of the view of the state. The decisions taken by the General Assembly proved to be helpful in the development of international law. These decisions recommendations and resolutions, and some of them are never implemented yet in the agreement between states and contribute in preparing the necessary environment for the development of the rules of international law. The resolutions and declarations of the General Assembly have capacity to become the sources of universal international law. In genocide, Judge Alvarez aptly remarked they, for example, resolutions of the General Assembly have yet not acquired a binding character, but they may acquire if they receive the support of public opinion. Further, in short, the Assembly is tending to become an international legislative power. In order that it may actually become such a power, what is needed that governments and public opinion should give it support, as pointed out by Rosalind Higgins. Collective acts of states repeated by and acquiesced in by sufficient numbers with sufficient frequency eventually attain the status of law. Thus, we see that the resolutions and declarations may serve as important means for the development of international law. They are extremely helpful in the process of treaty making and agreements between states on the various subjects. They have the capacity to become sources of universal international law, and if wisely used, they can prove to be very effective in the development of international law. In the words of Manfred Lasche, the then president of the International Court of Justice, a new phenomenon in international life is the activity of this assembly itself. I refer to your resolutions among the 3,000 adopted in 27 years. Not a few have made history. They have become a stepping stone, a stage in the political and legal process, a factor in the development of international law. Examples of some of the important lawmaking resolutions of the General Assembly, according to Brownlee, are the resolution which affirm the principles of international law recognized by the judgment of the Nuremberg Tribunal, the resolution on prohibition of the use of nuclear weapons for war purposes, the declaration on the granting of independence to colonial countries and people, the declaration on permanent sovereignty over natural resources, and the declaration of legal principle government activities of states in the exploration and use of outer space. Declaration on principles of international law concerning friendly relations and cooperation among states in accordance with the Charter of the UN 1970. Declaration on inadmissibility of intervention 1965. Universal Declaration of Human Rights 1948. Declaration of Principles Governing the Seabed and Ocean Floor and the Subsoil thereof 1970, etc. are international treaties or conventions and were not subject to ratification. Nevertheless, there is a wide consensus that these declarations actually established new rules of creating customary international law. Finally, in a rapidly changing world, the United Nations has found a method, albeit restricted by the rule of unanimity or cushy unanimity, to adopt the principles of its charter and the use of customary international law to the changing times with an efficiency which even its most founders did not anticipate. of sources of international law. After having after having discussed the different sources of international law, after having discussed the international sources of international law, the next important point that deserves our attention is the order in which these sources of international law are to be used. An authoritative order of the use of sources of international law is given in Article 38 of the Statute of International Court of Justice. The sources of international law have been mentioned in the said article in the following order. International Convention, Customs, General Principles of Law recognized by civilized nations, judicial decisions and juristic opinion, and subsidiary as subsidiary means for the determination of rules of law, the wordings of Article 38 suggest that sources are to by applied in the order in which they are mentioned and therefore treaties will take precedence over the other sources, but as pointed out by Manley O. Hudson, yet Article 38 did not establish a rigid hierarchy in applying a provision in a convention. The court may have to take into account the customary law prevailing when the convention was entered into or general principle of law as well as judicial precedents. A distinction we also have to be drawn between the categories in the categories listed, or they are not on an equal footing while it is possible to apply conventional or customary rule of law. It seems more proper to say that general principles of law, judicial precedents and juristic writings are only the nature of sources from which an applicable rule may be deduced. In Nicaragua versus USA, the workup by majority has taken the view that the sources of international law are not hierarchical but are necessarily complementary and interrelated. Interrelated sovereigns never clearly violated and they were rarely violated, and any attempt by an individual sovereign to violate them was condemned by sovereigns on concern. These very principles are the foundation of modern international law. Bhagavad Gita, which is regarded a wise religious text by Hindus, has not only classified just and unjust wars, but has also made a vivid discussion of them. The study of Bhagavad Gita also reveals that the declaration of war before its commencement was essential. The duties of the state in administrative and external matters have been vividly discussed in Kautilya's Arthashastra. According to Kautilya, just as well as unjust means could be used in wars. The study of the Ramayana and Mahabharata reveals that the study of Ramayana and Mahabharata reveals that during that period, diplomatic agents and world diplomatic agents enjoyed many privileges and immunities. International law relating to diplomatic agents was in its dual stage. Manu had propounded many principles and rules in his code, popularly known as Manu's code. In his view, wars could be either just or unjust. According to him, to fight and die in just war was a good deed. Indeed, in the view of Manu, receipt or poisonous weapons were prohibited in war. To kill wounded or sick soldiers in war were contrary to the rules of law. There were also definite rules relating to the treatment of prisoners of war. Thus, international law was at a developed stage in India. Thus, it may be rightly concluded that Hindus contributed much to the development of international law. Muslims, the Muslims or Muslim rulers of India had relations with other nations. They received the ambassadors of other states and entered into treaties with them. They had formulated some rules which governed relations with Muslim states. The Muslim rulers recognized the distinction between combatants and non-combatants and had formulated rules for according protection to women and children during war. They observed their treaties in good faith. History and development of international law, including schools of international law. History and development of international law. History and development of international law, including schools of international law. What is its origin? International law, as we find today, is the product of the experience of the civilized countries of the world and the continuous growth of many countries. Rules which may be described as rules of international law are to be found in the history both of ancient and medieval worlds. For our since men begin to organize their common life in political communities, they have felt the need of some system of rules, however rudimentary, to regulate their inter-community relation. According to Professor Oppenheim, if it, for example, international law is in its origin essentially a product of Christian civilization and began gradually to grow from the second half of the Middle Ages. The claim of the European scholars that the credit of giving birth to international law as we know today goes to the European countries is not correct. The allegation of Western jurists Oppenheim and others that international law originated in Europe and is the creation of Western civilization is falsified by a study of the original text of the Ramayana and of the Mahabharata. It leads us nowhere to hold that modern international law is only 3 or 4 centuries old, such as such an attitude is not only too logistic, such an attitude is not only too legalistic but is clearly disproved by the present practice which do take account of history. In India, too, there can be found in the work of Kautilya in the 4th century BC elaborate rules for the conduct of diplomacy. as a means of avoiding conflicts and the reception and treatment of diplomats. Study of the Ramayana reveals that in the Ramayana period, relations of the sovereign rules were based on the definite rules of international law, and these rules were recognized by all sovereign rules. In this view, these very principles are the foundation of modern international law. Although it is true that the international law had attained a sufficient stage of development in ancient India, yet it must be considered that as a definite branch of jurisprudence and the system which we know as international law is modern, dating from the 16th and 17th century, for its special character has been determined by that of the modern European state system, which was itself shaped in the ferment of Renaissance and the Reformation. So far as the origin of the international law is concerned, almost all the civilized states have made their contribution in its development. In this connection, the contribution of Jews, Romans, Greeks, Hindus, and Muslims deserve a special mention. A brief description of their contribution is being given. Uh, Contribution of Jews, Greeks, Romans, Hindus, and Muslims. Jews, a study of the ancient history reveals that the Jews had relations with other countries. Their relations with other countries were regulated and governed by certain rules. The famous slogan of the Jews, "Love and a stranger, for you are stranger in the land of Egypt." It is clear from this slogan that they believed in internationalism, but since they believed in monism in respect of religion, they did not treat those nations on the basis of equality, which believed in dualism or plurality of gods. The Jews strictly followed the treaties entered into by them with other countries and conferred privileges and immunities upon the diplomatic envoys. Thus, the Jews made some contribution in the development of international law in the ancient period. Greeks, it is clear from the study of ancient history that when most of other states of the world were backward and less civilized, the Greek civilization was quite advanced and the Greeks had achieved great advancements in different fields. Socrates, Plato, Aristotle, and other philosophers of Greece enlightened, enlightened the world through their ideas and philosophy. Greeks lived in small city states. The mutual relations of these states were regulated and governed by some definite rules and principles. They had formulated definite rules of war and peace. They used to resolve their dispute through arbitration. Prior declaration was made before the commencement of war. There was also provision for the exchange of toys. There was also provision for the exchange of prisoners of war, but there was a custom of ransom for the release of some types of prisoners. The Greeks had formulated many laws relating to war. Oppenheim has rightly remarked that the Greeks had shown to the world how sovereign states could live in mutual cooperation with each other like a single community. It may, however, be noted that the Greeks had more talents for development of art and philosophy than for the development of law. Nevertheless, the Greeks' philosophy, ideas, and their practices indirectly contributed to the development of international law. as compared to the Greeks, Romans were endowed with the far greater talents for the development of international law. Although, although modern international law is ordinarily regarded as dating from the 16th and 17th centuries, it cannot be denied that the Romans contributed much to the development of modern international law. In its early period, Rome was a small city-state and had relations with other states. These relations were based on the rules of international law. Subsequently, the Roman Empire greatly expanded, yet the Romans always considered themselves bound by laws and rules on the basis of laws. Romans deserve the credit for developing the laws of war. According to them, there were two types of war, just and unjust. Main grounds of waging just wars were attack on Roman territories. One is attack on Roman territories, which is disregard for the violation of the privileges of ambassadors. Three is contravention of treaties. Four is assistance to enemy states by friendly countries of Rome. According to Romans, the modes of termination of war were through treaty of peace and through treaty of peace and through conquest and annexation of the conquered territories. Similarly, the Romans had divided the treaties into three categories: treaty of friendship, treaty of alliance, treaty of hospitality. The Romans strictly adhered to the provisions of the treaty, and in their view, prior intimation was necessary for termination of treaty. Thus, the Romans made significant contribution in the development of international law. The position of Roman law in Europe in 16th century had important bearing on the beginning of international law. Hindus, as pointed out, as pointed out earlier, some of the rules of international law were in quite a developed stage in ancient India. A thorough study of the Ramayana, Mahabharata, Manusmriti, Kautilya Arthashastra will justify the truthfulness of this statement. The students of international law will learn from a study of Valmiki Ramayana that the relations between sovereign authorities of the Ramayana were governed by conduct based on principles which were recognized and ordered by all the sovereignty. They were